nauseum, the two wheels of the chariot. Now let us see this chariot work.
It is, in my humble submission, is that they are relevant.
I think competence of a law has never been, as far as
I certainly want to hear a person's point of view.
Is decided on the basis of newspaper reports. Those are other contexts.
Yes, legislative competence is a separate issue. I am dealing right now with the independence of
right now
the seeming infringement.
No, but independence of the judiciary itself is, if it is violated, then the law is incompetent. Competence is not just legislative competence. Competence is also competence vis-a-vis other provisions of the Constitution.
My lord,
And what the people perceive independence to be, and more so than the people, those dealing with the law, which is the legal community. So I definitely want to see the perception of independence. I mean, it may be very independent, but people may think it otherwise, and vice versa. It may not be independent, and people may think it very independent. So yes, you don't have to spend a lot of time on it. If you can just refer to them or give it to us.
They are at pages 171 to 185. And they are resolutions that what I was able to discover were only dating back till 2018. But I understand PBC has filed something going back to 10 years ago. But there is just one aspect of those resolutions that I would ask your lordships to consider. And that goes to some of the questions that have been raised. If your lordship sees that initially in all those resolutions, the request was for this court to amend the Supreme Court rules to regulate the suo motu power and to regulate the master of roster power. That was the demand for the major period. Eventually, there has been a change in the tone and direction in the last 2 or 3 years, which has then now, in the more recent resolutions, asked for Parliament itself to directly act under 175 and 191. And presumably, the change in direction was because there was no effective response from this court on its administrative side. I'll move on, sir. Now, Justice Hilali had asked two pertinent questions, and Mr. Zahid Ibrahim had also pointed out the need to look outside. And those two questions was, one, if the CJ's power to form benches and assign cases was taken away, what would be left of the CJ's office? And secondly, how the formation of benches and fixation of cases is dealt with in other countries. Now, the answer to that first question is that there are certain specific powers and rights of the Chief Justice that are enshrined in the Constitution itself. There are about 9 that I can think of. I'm not going to go through them all, but they are there in my concise statement. Apart from the ceremonial powers, there are 9 concrete powers. The power to make benches and assign cases is not a constitutional power at all. It is not mentioned anywhere in the Constitution. In 1935, in the Government of India Act, it was indeed a constitutional power of the Chief Justice. In the 1956 power, there was a direct provision in the 1935 Act. In 1956,
प्रैक्टिस एंड प्रोसीजर एक्ट समाज जारी है और न्यूज स्टूडियो से अब तक इतना ही। देखते रहिए एबीएन न्यूज कॉम की सोच।